The Commonwealth of Virginia, also known, is home to a rich history and diversity of culture. It is also home to some of the oldest institutions, the oldest continuous judicial body model for the United States Supreme Court. For centuries, justice has been administered in courtrooms across Virginia, from some of the smallest disputes all the way to landmark cases that have shaped the very fabric of our nation. The crowning achievement in our justice system is the right to trial by jury.
Welcome. My name is Bernard Goodwin. I serve as the Chief Justice of the Supreme Court. You have been selected as a prospective juror. Trial by jury in many cases is a fundamental right by the Constitution of the United States. Responsibilities as a juror are extremely important to our system of justice. When people have their cases tried by a jury, oath to render a fair. That verdict must be based upon the evidence. As jurors, you will consider the evidence presented through the testimony of witnesses and possibly through exhibits. You will be instructed about the applicable law by the presiding judge. It will be your duty to render a fair. In the next few minutes, duties of being a juror. I ask that you listen carefully and take your responsibilities seriously.
Somebody reporting for jury service for the first time, come in with an open mind. You might get picked, so be prepared to stay for the day. It's an exciting thing, and I think it's a privilege to sit on a jury. So,
I think I learned a lot of stuff. Wasn't sure what I was getting into when I got called for it, sort of looked at it as an inconvenience, but ended up learning a lot about the process.
Well, United States citizen and resident of our Commonwealth, you have been randomly selected to serve as a juror. Serving as a juror is one of the most important responsibilities of citizenship, and we want to thank you for your service. We hope this video will answer many of your and that you will become more familiar with the jury trial process. By the conclusion of your jury service, we trust you will leave with an even stronger understanding of our system of justice. Jury trials begin with a jury selection process. During jury selection, names are randomly selected from those on jury service to form a panel from which the trial jury will be selected. You may be assigned a number to have questions, please ask the jury coordinator. The jury coordinator sign in for jury duty in most courthouses, you may be given a badge to wear. While on court premises, you should always have this badge on display, as it lets everyone know you are an. During the jury selection process, you should remain in the jury room or appointed area, as you may be called upon at any time. The jury at any time during your jury service. There are two main categories of cases that could potentially require a jury: civil and criminal. A criminal case is a case in which someone is accused of committing a crime. A civil case is a lawsuit between two or more parties and typically involves monetary requests due to an event or disagreement between parties. There are some different civil jury trials that you should know. In a criminal case where a person faces a misdemeanor charge, 7 jurors will be selected to hear the case. If the person is found guilty, or, in other words, convicted, they may be fined or sentenced up to 12 months confinement. Charged with a felony. A person convicted of a felony offense may be sentenced to a fine, jail time, or prison time. If the jury finds the accused guilty, The court will determine the punishment for the offense unless the defendant requested punishment be decided by the jury. The number of jurors needed in a civil case generally depends on the amount of damages claimed by the plaintiff. Generally, 5 or 7 jurors will be selected to serve. In a civil jury trial, the jury decides the verdict and awards any damages. A civil case must be proven by greater weight of the evidence. In contrast, a criminal case must be proven beyond a reasonable doubt. When it is time for a jury to be selected, the bailiff will from the jury assembly room into the courtroom. Begins a panel of potential in a process known as voir dire is a method to determine whether a prospective juror can be fair and is otherwise. The clerk or bailiff will ask the potential jurors to stand, raise their right hand, and swear or affirm that they will truthfully answer the question. The judge will state the names of the parties, their attorneys, and witnesses involved in the case, and a brief description of the nature. Attorneys will ask questions to learn more. You may be asked about your occupation, personal if they could be relevant to the case. At times, an individual may be asked to explain their answer. If your answer is embarrassing or too personal to share with everyone, you can request to speak privately to the attorneys and the judge to explain your response. In the interest of providing a fair trial, it is extremely important for you, the potential juror, to acknowledge if you know any of the persons identified. You have any other conflict that will keep you from being fair to both parties in the case. The judge will excuse those on the panel whose knowledge of the people or circumstances would affect their impartiality. By questioning the jury panel, the attorneys narrow down the pool of jurors to the people who they think will be able to deliver a fair verdict in the case. There is no limit to the number of prospective jurors the attorneys may ask the court to strike for cause. Their requests will usually be made on the grounds that the juror cannot be impartial because they know a party in the case or a specific reason considered sufficient by the judge. There is, however, a fixed number of preemptory strikes each side is allowed. A preemptory strike means that the attorney does not need to state a reason to excuse a potential juror. However, an attorney may not use a preemptory strike to exclude a juror based on race or gender. You may be excused at this stage of the trial. Do not take your dismissal personally, as there are many potential reasons a person is not selected to sit in a particular case. You have already performed a valuable service just by being present and participating in the selection process. The jurors will take an oath promising to fairly decide the case. The trial is now ready to begin.
So some things that I realized that I needed to do to be a fair juror was to not include any bias that I may have in relevance to the case. So any issues that I may have had with the defendant, I had to make null and void in my own mind.
I think the first thing that I had to do during jury service was to immediately understand that making a decision at the beginning was the last thing to do.
In the first stage of the trial, the attorneys will have the opportunity to present opening statements. An opening statement is an overview of the case the party intends to prove and is not to be considered as evidence. After opening statements, each side will have the opportunity to provide evidence to support their case. Evidence may consist of, but is not limited to, witness testimony, documents, articles, photographs, or objects. Nearly anything that pertains to the case could potentially be offered as evidence. Once a lawyer has finished the direct questioning of a witness, the opposing lawyer will have the opportunity to cross-examine that witness. After the plaintiff in a civil case or the prosecutor in a criminal case has finished presenting evidence, that party will tell the judge that side rests its case. The defense is then given the opportunity, but is not required to present evidence. It is important that you pay close attention and carefully consider all the evidence. Keep an open mind and do not form any conclusions until you have heard all the evidence in the case. Trials are conducted according to rules, and objections are made to ensure the rules are followed. Occasionally, you may hear a lawyer object to a certain question asked of a witness or to certain evidence that is presented. Objections are made when a lawyer believes that there is an improper legal basis for a piece of evidence. The court will make a ruling on whether the potential evidence or witness testimony can be admitted and considered by the jury. If the judge rules the evidence should be allowed, the judge will overrule the objection, and the witness will be allowed to answer the question. However, if the judge agrees with the objection will be sustained, which means the jury will not be permitted to hear an answer to the question. From time to time during a trial, the attorneys may request a bench conference so they can discuss with the judge various legal issues, such as whether certain evidence may be admitted. The jury may even be asked to briefly leave so that the judge may discuss a matter in private with counsel. This may be frustrating to you, but it is important that as the juror you only hear evidence that the law allows to be presented in a case. During the trial, you may not discuss the case with anyone except your fellow jurors during deliberations. As a juror, you are only allowed to consider the evidence that is presented in the courtroom in making your decision. Therefore, whenever you are recessed from the courtroom for lunch, a break, or overnight, you are not allowed to discuss the case with anyone, including your family, friends, or fellow jurors. If anyone tries to discuss the case with you, notify the judge immediately.
It was tough not to talk to family and friends once I was picked for the jury about what was going on, especially because we don't see a lot of cases or, criminal acts every day. So it was kind of exciting to hear the evidence in the case, and I wanted to share that with others, but couldn't.
During your service as a juror in a trial, do not do any independent research on the case. You should avoid any newspaper, television, news programming, or social media that could include information about the trial in which you are sitting as a juror. Please do not send or accept any electronic communications about the case for the duration of the trial. Even if you inadvertently receive information about the case from an outside source, such as social media or a text message on your phone, you could jeopardize the fairness of the trial or even cause a mistrial. Your role as a juror is to determine the facts of the case based on an evaluation of all the evidence the judge rules admissible.
It was a little difficult not being able to express things about the case during my breaks with friends and family, but at the end of the day, I knew it was best for the case, for the outcome.
After both sides have finished presenting their evidence, the judge will instruct you on the law in the case. It is your job as the juror to find them. The judge's instructions are the law in the case, and you must follow them during deliberations. After the instructions are given, each side will present closing arguments. Closing arguments summarize each side's view of what the evidence does and does not support. During closing arguments, the attorneys for each side will give the reasons why the jury should decide in favor of that side. Like opening statements, the closing arguments are not to be considered as evidence. Once you have heard closing arguments, you will be escorted to the jury deliberation room, where you will begin discussing the case with your fellow jurors in confidentiality. At this point, the case is in the jury's hands for decision. In the jury room, the jurors should elect a foreperson to lead the deliberations. The foreperson is responsible for maintaining order during deliberations. If you have a question, the foreperson should write it down and give it to the bailiff, who will take it to the judge. During deliberations, speak freely and keep an open mind. Listen to the opinions and points of views of the other jurors, but make your own decision. Were the witnesses credible? Was the evidence convincing? After a full discussion of the issues, you will each need to state your decision. If you do not agree with your fellow jurors, you may continue to discuss the case. In both criminal and civil cases, a jury's decision must be unanimous. When the jury has reached its unanimous verdict, The foreperson must sign the verdict form and notify the bailiff. The bailiff will alert the judge, and all parties will be summoned back into court. After the verdict is announced, the lawyers may ask the judge to question the jurors individually to confirm that the verdict is accurate. This is called polling the jury. After the jury has returned its verdict, the judge will then dismiss the jury, and you will be free to leave and to discuss the case with anyone.
It's very important to report to jury services because everyone is entitled to be heard and to have a fair trial. And it's important to do your duty as a citizen. It's part of the American way.
The right to a trial by jury is a cornerstone of our democracy, and your service as a juror is vital to the proper operation of our system of justice. I hope you will find jury service to be a rewarding experience. Thank you for being here today, and thank you for your willingness to serve your community.